Mr. President, as we prepare to celebrate Mother's Day this Sunday, I am today introducing a joint resolution which would remove the deadline for the state's ratification of the Equal Rights Amendment, the ERA. I want to thank my co-sponsors. As of this morning, my co-sponsor included Senator Kirk, Senator Mikulski, Senator Murkowski, Harkin, Sanders, Levin, Menendez, Stabenow, Heinrich, Boxer, Gillibrand, Durbin, Lautenberg, Murphy, Baldwin, Landrieu, Brown, and Begich. When Congress passed the ERA in 1972, it provided that the measure had to be ratified by 3/4 of the states, 38 states, within 7 years. This deadline was later extended to 10 years by a joint resolution enacted by Congress, but ultimately only 35 of the 38 states required ratified the ERA when the deadline expired in 1982. Congress has the authority to give the states another chance and should do so. In 1992, I just want to point out to my colleagues that the 27th Amendment to the Constitution prohibiting immediate congressional pay raise was ratified after 203 years. So this additional delay is certainly in keeping with our prior precedent. Article 5 of the Constitution contains no time limit for the ratification of constitutional changes. And the ERA time limit was contained in a joint resolution, not the actual text of the amendment. The 14th Amendment of the Constitution requires equal protection of the laws, and the Supreme Court has so far held that most sex and gender classifications are subject only to intermediate scrutiny when analyzing the laws that may have a discriminatory impact. In other words, right now, gender discrimination does not have the strict interpretation standard. It's not subject to the higher standard, which it should be. In 2011, Supreme Court Justice Scalia gave an interview in which he stated, and I'm going to quote his interview, and this is an exact quote, "Certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't," end quote. In other words, we don't have that protection in the Constitution today. Ratification of the ERA by state legislatures would provide the courts with the clear guidance on holding gender or sex clarification to the strict standard that's set. The ERA is a simple and straightforward constitutional amendment. It reads, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex," end quote. The amendment gives power to Congress to enforce its provisions by appropriate legislation, and the amendment would take effect 2 years after ratification. Today, nearly half the states have a version of ERA written into their state constitution. My own state of Maryland's constitution reads that equality of rights under the law shall not be abridged or denied because of sex. I'm therefore pleased to introduce this joint resolution today, and I thank Representative Andrews for introducing a companion version in the House today as well. This legislation is endorsed by a wide variety of groups, including United for Equality, National Council of Women's Organization, American Association of University Women, Business and Professional Women's Foundation, Federally Employed Women, the U.S. Women's Chamber of Congress. I urge my colleagues to support this legislation.